All right, good evening, folks. Welcome to Monday Night Law here in Kirk's Law Corner. December 18th, 2023, winding down the year. Here we go. Christmas is around the corner. Is everybody ready? Good times. Cold weather, warm weather, depending on where you're at. Hope everybody's doing all right, hanging in there. Yep, kicking 2023 to the wind, right? Goodbye 2023. We're still in for a little bit of a bumpy ride between now and the end of this plan, 7-year plan. Woohoo! First snow in Kentucky, huh? We got rain today. It was 35 degrees and it was raining. I swore it was going to turn into snow, but nope. Just rain. Hi, CC from Alaska. How are you doing out there? Neo Truther Tiger, corruption detector over here on Telegram. Leslie over on Telegram. So tonight we're going to go over, kind of pick up where I left off a couple weeks ago with Blackstone's Commentaries on the Law of England about rights stuff, right? And getting into that absolute rights. I know there's a couple of questions out there regarding like Article 3 stuff, but I'm gonna stick to kind of what has come to me for tonight, which is to pick back up where I left off a couple weeks ago on the Blackstone's Commentaries on the Law of England. So, just want to remind people that things are happening all over the place, and if it's not in the mainstream media, that doesn't mean that it's not happening. If we haven't all figured out by now that mainstream media is a fraud, a scam, it's fake. It's all fake propaganda, okay? And if this is the first time you've heard that, I highly recommend start looking at different sources for information. Now, mostly over here on Telegram. I share sometimes from realrawnews.com. And I want to clarify this for people because I get that it says it's for satire. Okay? But the thing is uh-oh. Okay, hopefully that's working over there. Was having a little bit of issue with Rumble tonight getting going, and it appears that it is not really working. But let me see. Nope. Okay, it is working. Well, no, it is not. Well, dang it. Yeah, I wondered if it was going to do something weird over there on Rumble. It was having an issue getting it going. So, I'm putting a comment out here. Yeah, it's not. There it goes. Yep. And I don't know if I can. There's no way I can fix it from here right now. Cannot change these settings while you're live. Yep. Oh well. Nothing I can do about it over there on Rumble tonight. Oh, man. Brother Rob, good to see you. Walter Douglas, Neo-Truther. But back to the fake news, right? If you haven't heard that before, it is. Real Raw News. Where was that? Real Raw News. Okay, folks. When I first came across Real Raw News, their disclaimer said some or all of this may be true, but is to be considered as satire only. So, what they're saying is it's true, but it is to be considered as satire. That is to protect themselves. That's why it's called a disclaimer. And since they have changed it at least 3 times that I'm aware of, and we have to understand, again, what is it? It's real, it's raw, and it's the news. Mainstream media is not going to put any of that stuff out. Okay? And my understanding is the source of that is through some sort of source through the Pentagon or something like that. Military-ish. So, take it with a grain of salt, folks. It's about the closest to the truth that you're probably going to get out there about what's really going on, other than outside sources of outside of mainstream media, which worldwide, you're not getting any of that. And I want to remind people, again, we are at war. If you're not in the need to know, you're not going to know. Even in the military, that's the way it works. Right, in the Marine Corps, many times, hurry up and wait, hurry up and wait, hurry up and wait. Just do as you're told. Well, what's going on? None of your business. Just do what you're told. So if you think you out here, you and I out here as civilians are going to get told what's really going on, while military personnel who's active duty and that kind of stuff aren't told what's going on until it happens. But they're in the military. They're the ones taking the actions. And they still really don't know the bigger picture, just what's in front of them and what they're told to do. If you think that you and I as a civilian are going to get that information, you are sadly mistaken. You have been misinformed about who gets what kind of information. It's a fact, okay? That's just how that works. So, keep that in mind. And I'm mostly speaking over here on Telegram when I share the Real Raw News links to their news. Okay? Right, James? I know nothing. Oh, good old Colonel Clank, right? Yep. Wasn't it Schultz? I thought it was Schultz that was, I know nothing. And I've adopted that. I know nothing. I don't claim to know anything. That way I can't be held to know anything. But here's a few things I'd like to share with you. So, I'm just gonna dig right into this Blackstone's Commentaries on the Law of England here. And now, some of the verbiage here, it says persons and that kind of stuff. Now, part of the problem here is this is kind of revolving around the civil law, Roman civil law. Even though the common law of England is supposed to be separate, they're kind of blended. And I had found in Bouvet's Law Dictionary where it talks about that natural rights, or no, it was in American Jurisprudence, Volume 15, 2017, update, Section 2 under Civil Rights. and I did a search for natural rights, they said, oh, well, natural rights, blah, 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 but they've been acquired anew through the civil law. Yep, the code, Roman civil law. So, no, this is a problem. Because we don't actually, they don't recognize them, that they come, I mean, as we'll see here, it says persons, and then natural persons are such as the God of nature formed us. Okay, that's man. But then they use the word man. So, which is it? Okay? And, I suppose there's one little thing here I could do real quick. We'll go over here. And I believe it was 1600-ish. And it was the rights of man. Uh-oh. That one didn't work. Which is weird. It should have. Maybe it was 1700. Oh, fat fingers. There we go. It was 1789. Declaration of the Rights of Man. Now, this came from France. Frenchy, right? As a National Assembly. Why is this always, we're talking about some sort of assembly here? It's a wonder why on the National Assembly, that we're national-assembly.net, that we're talking about the General Assembly and the General Jural Assembly. Okay, and there's a clear distinction between the General Assembly and the General Jural Assembly. So, this is in part what we are trying to do, is reassemble government de jure, the common law side of our republic. Many people are not aware of our true republican form of government. You got that case out there, U.S. versus William, that the common law grand jury is not part of the legislative, executive, judicial. It's separate. Essentially, I have not found in that case where it says, oh, it's essentially a fourth branch of government. Well, it's not. It's the first branch, because this is the power of the people, and it comes first. You have to have this assembled first in order to create the legislative, executive, and judicial branch. This is fundamental, folks. This is how our republic works. All political power is inherent in the people. So the people have to come together and assemble first. Then we create the instrument of government that serves us, serves them. That is the key to understanding our republican form of government. Karen over on YouTube making fun of me using Control F. Yep, you bet. I know like one or two tricks. I'll reiterate, I'm not much of an end user. I know how to build them, network them, install software so that the end user can use the software. But I'm not very good at using the software. So, anywho, notice that this is rights of man. Men are born to remain free and equal in rights. Social distinctions may be founded only upon the general good, the aim of the political association, the preservation of the natural and imprescriptible rights of man. These rights are liberty, property, security, and resistance to oppression. Whoa, wait a minute. That's a fundamental, natural, God-given right to resist oppression? The principle of all sovereignty resides essentially in the nation. No body nor individual may exercise any authority which does not proceed directly from the nation. Now, this is France, and America. We did something a little bit different. Nonetheless, this is a great read. Liberty consists in the freedom to do everything which injures no one else. Okay, that is an absolute right. Freedom, free dominion over everything. Land, air, and water. Genesis 1:26 through 28. Well, let's just, you know what? Because many people aren't even aware of that. So let me pull out my Bible here. Now this is reading from my founder's Bible. We'll go right to the beginning here. Genesis 1:26 through 28. What does it say as it is essentially written? Genesis 1:26. Then God said, "Let us make man in our image, according to our likeness, and let them rule over the fish of the sea," and it's actually supposed to be water, "and over the birds of the sky," which should be air, "and over the cattle, and all over the earth, the land, and over every creepy thing that creeps on the earth." 27. God created man in his own image. In the image of God he created him. Male and female he created them. 28. God blessed them, and God said to them, "Be fruitful and multiply, and fill the earth, and subdue it, and rule over the fish of the sea," should be water, "and over the birds of the sky," should be air, "and over every living thing that moves on the earth." I'll even go into number 20, maybe even a little bit more. 29. Then God said, "Behold, I have given you every plant yielding seed that is on the surface of all the earth, and every tree which has fruit yielding seed. It shall be food for you. And to every beast of the earth, and to every bird of the sky, and to everything that moves on the earth which has life, I have given every green plant for food," and it was so. 31. God saw all that he had made, and behold, it was very good, and there was evening, and there was morning, the sixth day. So, that's freedom. Supposed to have dominion over the beast of the land, over the fowl of the air, and the fish of the water. Because there's a lot more fish than just in the sea. So, there's some of them words that have been fundamentally altered from the original texts, which is the origin of the word law. Law of the land, law of the air, and law of the water. All right. So that's where we have freedom, free dominion. And liberty, technically kind of speaking, is actually a military term. When you're done for the day, you're out on liberty. And weekends, you're out on liberty. You're free to do whatever you want to do as long as you don't cause any harm or injury to anyone else. Hence, the exercise of natural rights of each man has no limits except those which assure to the other members of society the enjoyment of the same rights. You mean rights that we have in common, like common law? Right says law. Remember, that's a French word, droit, meaning right or law. So they're synonymous. Wherever it says right, you can replace it with law. And wherever it says law, you can replace it with right. And when you take something that says law and you replace it with right and it doesn't make sense, that's because it's not law. It's policy. Okay? Things that are made by man, technically speaking, are not law. All right. Each has man no limits except those which assure the other members. These limits can only be determined, by law. By law? Bylaws of a corporation. There can be, you can't say on one hand that you have this right from nature to do everything you want to do so long as it doesn't cause harm to another man, and then turn around and say, well, we can limit that. No, you cannot. Oh, okay. Well, let's look at number 5. Law can only prohibit such actions as are hurtful to society. Now, there we go. That causes harm. Nothing may be prevented which is not forbidden by law, and no one may be forced to do anything not provided for by law. But if you look at the law of nature, where life, liberty, the pursuit of happiness comes from, that would be the law that would prohibit that. And if this law of nature is the fundamental law, then man-made so-called law cannot come in conflict with the fundamental principles of the laws of nature, which is what the law of nations talks about. Doesn't matter what you do with your creating of government, at no time can you supersede the law of nature. Because that is essentially what the intent of government is to secure those rights from infringement. Therefore, how can they have the power to subvert those rights if the intent of creating government was to secure those rights from infringement? Makes absolutely no logical sense. Not to me. I'm hoping that makes logical sense to the rest of you out there. That we would have something fundamental such as liberty, and then we would create government to secure that right of liberty, which is the freedom to do whatever the heck we want to do, so long as we do not cause injury, loss, or harm to our fellow man. And that we get away from that intent of creating government to secure that right, to ensure that not even government infringes on those rights, because man himself cannot infringe on those rights. Therefore, no set of men, no body or individual, may exercise authority does not proceed directly from the nation. How can we delegate a power we do not possess ourselves first? Completely illogical. Law is the expression of the general will. Every citizen has a right to participate personally or through his representative in its foundation. Now, that's in that general assembly. It must be the same for all, whether it protects or punishes. Oh, you mean that the law must apply equally to all? All citizens, being equal in the eyes of the law, are equally eligible to all dignities and to all public positions and occupations according to their abilities and without distinction except that of their virtues and talents. No, would we really say that you kind of need to be qualified for the job? That's the exception. You kind of need to be qualified. right? We don't hire plumbers to do electrical work because they're educated and knowledgeable, and their virtues and talents are from to do plumbing, not electrical. No person shall be accused, arrested, or imprisoned except in cases according to the forms prescribed by law. Now, this is where we get into what's happened here in America. Is they've changed from the laws of nature and the common law, American common law, by and through the English common law, and subverted that, replaced it with the Roman civil law, the code. Yes, absolutely. Good question out there. Art, brother Art out there. Does the Constitution presuppose the people have already set up common law courts? Well, I'll be darned. Let's just read that real quick. I know this is getting kind of off track, but what does Article the 7th read? As it is written. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury, not jury trial, it is a right of trial by jury, shall be preserved. Now, here's the key. And no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. Now, wait a minute here. Is that not a clear indication that our common law courts are not courts of the United States? Because that's what it says. It cannot otherwise be re-examined in any court of the United States. That would include state or federal, because they're all courts of the United States. Whether people realize that or not, that's a fact. New states may be admitted to the Union, and oh, well, that's right, our Republican form of government. These are all courts of the United States. Now, where are our common law courts? Which start as a trial by jury, starts with the grand jury. The whole thing, not like what we're accustomed to today. That's not a true trial by jury. A trial by jury starts with a grand jury indictment or presentment of a grand jury. Then you can proceed. So, hopefully there's the answer for you there, Brother Art. And like I've said before, the common law side of things of our Republican form of government is already done by the people themselves, and they're supposed to be electing their justices of the peace. On a local level. Okay? No person shall be accused, arrested, or imprisoned except in the cases according to the forms prescribed by law. And that's what we said. Formed by law, right? Here's laying down the law. See, in our form of government, we made it so that we, the people, declare or lay down the law. Declarations. Declare. D meaning down. Clarify. In writing. And this goes back to American Jurisprudence, Volume 16, Constitutional Law, Section 100 from my 2017 update when I was down at the law library. says that bills of rights and those merely declaratory of the common law. What? Wouldn't this Bill of Rights here be merely declaratory of the common law? Like Hale versus Henkel says, that our rights are long antecedent to the formation of the state? That's right. Clear back to Blackstone's Commentaries on the Law of England and way further back than that. Like the right to a trial by jury actually stems from the Aziz of Clarendon, clear back to 1166. So how is it in 2023 that we don't know about the right to trial by jury and how that's supposed to work? Well, it's because it's been subverted. It's been hijacked by the bar. And we've all been, now we're being subjected to this Roman civil law code, and now we have civil rights instead of natural rights. And, you know, the thing is, well, who created the Bill of Rights? Wasn't that all of the states in convention? So if the states created it, how does it not apply to the states itself? You know, you look at the 10th Amendment, what does it say? The powers not delegated to the United States by the Constitution, nor prohibited by to the states are reserved to the states respectively or to the people. Well, this is in the Bill of Rights. What does it mean by the Constitution? That's because this becomes part of the Constitution. So if we're going to say that the Bill of Rights doesn't apply to the states except for by and through the 14th Amendment, what the hell did we do prior to the 14th Amendment? Hogwash. Let's see. Anyone soliciting, transmitting, executing, or causing to be executed in any arbitrary order shall be punished. But any citizen summoned or arrested in virtue of the law shall submit without delay, as resistant constitutes an offense. Would that be like what I'm being charged with, resisting and obstructing? But you have to follow this first. By any citizen summoned or arrested in virtue of the law. So this is why I say arrests must be lawful. That would be resisting a lawful arrest. And resistance is actually physical, not verbal. The law shall provide for punishments, blah, 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 are strictly and obviously necessary, and no one shall suffer punishment except it be legally inflicted in virtue of law, passed and promulgated before the commission of the offense. But we're not supposed to have bills of attainder and bills of pains and penalties in our republic. So you can't create legislation that promises an award before any commission of any crime. That's ex post facto. But then again, when they do like their fines and jail time stuff, that promises an award prior to. And then the thing is who gets the fine? Where's the accuser? Oh, but this is Roman civil law, the code, and it's all enforced through bills of pains and penalties. So we're doing prosecution by information now. No, that violates the Magna Carta. Clear back to 1215. Not supposed to do that. You can't have any unsupported claims. You can't be the accuser and the witness at the same time. And not only that, you didn't witness any crime. Well, maybe in some instances, the sheriff or deputy or policy officer might witness a crime. But that would be the best he could be as a witness. Can't be the accuser unless he's actually the one being harmed, right? As all persons are held innocent until they shall have been declared guilty. If arrest shall be deemed indispensable, all harshness not essential to the securing of the prisoner's person shall be severely repressed by law. No one shall be disquieted on account of his opinions, including his religious views, provided their manifestation does not disturb the public order established by law. The free communication of ideas and opinions is one of the most precious of the rights of man. Every citizen may accordingly speak, write, and print with freedom, but shall be, here again, folks, it's not accountable, it's responsible for such abuse of this freedom as shall be defined by law. Now, we call that libel and slander from the common law, which is criminal in nature. Not civil in nature, it's criminal in nature. But it's free communication of ideas and opinions. It's one of the most precious of the rights of man. Some of our founders called it one of the greatest bulwarks of liberty is the liberty of the press. The ability to speak or write or print with freedom is one of the greatest bulwarks of liberty. Why do you think that's in the First Amendment, or Article the First of the Bill of Rights? They thought it very important to have that one right up in there. But it's one of the most precious rights of man. The security of the rights of man and of the citizen requires public military forces. These forces are therefore established for the good of all and not for the personal advantage of those whom they shall be entrusted. Oh. This is that no standing armies, no armed bodies of men, except for a well-regulated militia. That would be the organized militia. But the militia itself, the unorganized, starts with, and it is composed of, the body of the people themselves. Then the organized by the state is the well-regulated. The organized militia of federal is that organized portion of the militia. But every male between the age of 17 to 64, is automatically duty bound to be in the unorganized portion of the militia. That's that's part of being an American. And that is why it says the right of the people to keep and bear arms shall not be infringed, because the people are supposed to be armed and the military is subordinate to the civil power. They're only called in when we, the people, the unorganized by government militia, can't handle the situation. That's a fact of law. Common contribution is essential for the maintenance of the public forces and for the cost of administration. This should be equitably distributed among, equitable interest, distributed among all citizens in proportion to their means. All the citizens have a right to decide, either personally or by their representatives, as the necessity of the public contribution. To grant this freely, to know to what uses it is put, and to fix the proportion, the mode of assessment, and of collection, and the duration of the taxes. Society has a right to require of every public agent an account of his administration. Now, account, that's money. Appropriations, money. Accounting, like your bank account. A society in which the observance of the law is not assured, nor the separation of powers defined, has no constitution at all. That's why we're supposed to have a constitution. It's the conscience. Since property is an inviolable and sacred right, no one shall be deprived thereof except where public necessity, legally determined, shall clearly demand it, and then only on condition that the owner shall have been previously and equitably indemnified. So this goes into that so-called right to travel, which is actually personal liberty, which consists in the power of locomotion. We're going to see that here in a minute, going into Blackstone's. And coupled with the right to acquire and possess and utilize our personal property how we see fit. We only gave them the power to regulate foreign and interstate commerce. That's it. And that's one of those things that's in the Declaration for the Causes and Necessity of Taking Up Arms in 1775 there, that interdicting all commerce onto the people. And that's what they've done. Again, okay, the objects of the law being fallen into this fourfold division, the present commentaries will therefore consist of the four following parts. The rights of persons, and so we're going to change that from persons to man, with the means whereby such rights may be either acquired or lost. The rights of things, with the means of acquiring and losing them. Private wrongs or civil injuries, with the means of redressing them by law. Public wrongs or crimes and misdemeanors, with the means of preventing and punishment. You are now first to consider the rights of persons with the means of acquiring or losing them. Now, the rights of persons that are commanded to be observed by the municipal laws, see, municipal, now we're talking, this is Roman civil law, are of two sorts. First, such as are due from every citizen, which are usually called civil duties. And secondly, such as belong to him, which is more popular exception of rights or jura, like jurisdiction? No, that would be juris, pardon me. Both may indeed be comprised in this latter division, for as all social duties are the relative nature, at the same time that they are due from one man or set of men, they must also be due to another. Now they want to use the word man. Okay? But I apprehend it will be more clear and easy to consider many of them as duties required from, rather than as rights belonging to particular persons. So this is like what Bouvet talks about, this is rights impose duties. Where one has a right, the other has a duty. Thus, for instance, allegiance is usually, and therefore most easily considered as the duty of the people, and protection as the duty of the magistrate. And yet they are reciprocally, the rights as well as duties of each other. Allegiance is the right of the magistrate, and protection the right of the people. Persons are also divided by the law into either natural persons or artificial. Natural persons are such as the God of nature formed us. So that wouldn't be natural persons, that would be man, as I just read. But somebody had informed me, and I vaguely remember this, talking about in the Bible where it talks about that we're not supposed to deal in persons, to stay away with claiming a title such as a person. We are man, creation of God, plain and simple. God created man in his image. He didn't create persons or natural persons. This is Roman civil law trying to get away from the actual creation of man. It's subversion. Artificial are such as created and devised by human laws for the purpose of society and government, which are called corporations or bodies politic. What? Corporations or bodies politic? The rights of persons considered in their natural capacities are also of two sorts, absolute and relative. Absolute, which are such as appertain and belong to particular men, merely as individuals or single persons. Let's just get rid of that verbiage and just say that these are absolute rights of man. Period. Relative, which are incident to them as members of society and standing in various relations to each other. The first, that is, absolute rights, will be the subject of the present chapter. By the absolute rights of individuals, well, no, let's change that again. See how he's just changing this up. Keep it as rights of man. We mean those which are in their primary and strictest sense, such as would belong to their persons, merely in a state of nature, and which every man is entitled to enjoy, whether out of society or in it. That's why they're supposed to be called natural rights, because those rights come from God, from the law of nature. Okay? Naturally, fundamentally, and principally, we have these fundamental rights, natural rights of man, because God endowed man with rights, sovereignty. It is not to be expected. But with regard to the absolute duties which man is bound to perform, considered as a mere individual, it is not to be expected that any human municipal law should at all explain or enforce them. Now this goes back to that volume 15, Civil Rights, section 2. Natural rights and civil rights have absolutely nothing to do with the establishment, support, or management of government. We're the ones that's supposed to take care of that at common law, not the government. We're the ones that drag the public servants into the common law courts for trespassing our rights. That's why it's called a common law trespass. Okay? Because these particular rights is actually regarded as property. That's even in the commentaries, the commission, that report of the Commission on Unalienable Rights. It specifically states in there that our rights are regarded as property from the common law. And that is why it is called a common law trespass, because you're trespassing on our property, an aggregate of guaranteed rights. Those are unalienable. When you apply that as unalienable, you can't place a lien upon them, is because they are our property. You cannot hold our rights, our property, for a debt, because that's what a lien is. That's why our founders meant unalienable rights. Among these are life, liberty, and the pursuit of happiness. Because they come from nature, they come from God. They're not made by man. They're outside of man, before government. So man has no authority over them. They have a duty to respect them, not to trample on them. That's the "do not tread on me," the Gadsden flag. Okay? That's really what that means. Don't tread on my property, my rights. But man is bound to perform. Considered as mere individual, it is not to be expected that any municipal law should at all explain or enforce them. Right? It's not for government to explain or enforce. That's up to the people to do that. It suits at common law. If it was part of the municipal law, then that would be suits in law under Article 3. Common law courts are not Article 3 courts. Okay? Go read Article 3. Nowhere in there does it mention common law, but it mentions admiralty and maritime, but it does not mention common law. Now I get original jurisdiction stuff, but the thing is that's the review, like a writ of review, like a writ of habeas corpus, like a writ of mandamus, writ of prohibition, writ of quo warranto. Those are common law writs. That's the original jurisdiction to review of the Supreme Court. The Supreme Court is where writs are to be filed under original jurisdiction. But like it says in Article 3, it says the judicial power shall be vested in one Supreme Court and all such inferior courts as the legislature may create. And some people refer to this Article 1 courts. They still are under the one Supreme Court and the judicial power from Article 3, which is admiralty and maritime jurisdiction. That's it. They don't get to make up new jurisdictions. They do not get to extend admiralty jurisdiction onto the land. Those courts of the United States are very limited in their scope and authority, jurisdiction. Okay? For the end and intent of such laws being only to regulate the behavior of mankind, that's why it's a suit at common law, not a suit in law under Article 3. As they are members of society and stand in various relations to each other, they have consequently no concern with any other but social or relative rights. That's right. See, we the people take care of this in our common law courts. Government only deals with that in law, incorporated into the body politic by a license or an oath member. They become a member. They become a citizen. That's that Law of Nations, Book 1, Chapter 19, subsection 212. Oh, wait. I might actually have that one right here. Well, it's going to be way further down than that, but... Huh, well, it's not working. I don't know why it's not. Ooh, now it's trying to work. There we go. You know, I know I've shown this before many times, but it needs to be, I think it needs to be said again or shown. So we can fully comprehend. Oh, wait. I'm in the wrong. That's book 3. I need to be back up here in book 1. Whoops. That's book 2. I need to bookmark that. There we go. Maybe. Yep. There we go. This is book 1, chapter 19, subsection 212, page 245 of the PDF that I have. Section 212, Citizens and Natives. The citizens are the members of a civil society, bound to this society by certain duties and subject to its authority. They equally participate in its advantages. That's that emoluments clause. Any advantage, profit, or gain received due to one's position, employment, or holding of office. So, right there, now that we are learning about the word citizen and a true definition from the law of nations, which that next part, which is, says the natives are natural born citizens, this is where in the Constitution the requirement to run for the office of president is you must be a natural born citizen. And they go, see Vittel 212. That's this section right here. That's what they're referring to right here. This is the definition of citizen and the definition of natural born citizen from the Constitution itself. This is where they pulled from. And I'll show you right now. The citizens are members and bound. Where is that found in the Constitution? Are you ready? Article 6, Clause 3. The senators and representatives before mentioned and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Nowhere does it say to interpret. No, they're bound to support it. Those are those duties to perform that the Constitution dictates that they are to perform. Now, those are the citizens. And so, this is where sovereign citizen is an oxymoron. Because they're the ones that give up their sovereignty in the exchange for the emoluments of the offices that they're either elected into or appointed into a position of public trust, which means an employee under an elected official. So, we are the people or the inhabitants, which is section 213. Remember, those are the three statuses we have here in America: inhabitants, people, and citizen. The citizens are the public servants. The people have all political power. The inhabitants are completely free and independent of government and anything like, oh, Kirk, but that's anarchy. And no, it is not. They live at the common law. They're free inhabitants. They have no duty other than to defend. That's about it. Even Hale versus Hinkle backs this up. You know, this is one of those times where you can tie this particular case, Hale versus Hinkle, into this verbiage, even from Blackstone. So if you want to use that, the word individual means man or people. Let me get down here to 74. If whenever an officer or employee of a corporation were summoned before a grand jury as a witness, he could refuse to produce the books and documents of such corporation upon the ground that they would incriminate the corporation itself, it would result in the failure of a large number of cases where the illegal combination was determinable only upon the examination of such papers. Notice that it is a grand jury that's doing the investigation over a corporation. Conceding that the witness was an officer of a corporation under investigation, and that he was entitled to assert the rights of corporation with respect to the production of his books and papers, we are of the opinion that there is a clear distinction in this particular between an individual and a corporation. What? Wait, what? That there's a clear distinction between the two? And that the latter, the corporation, has no right to refuse to submit its books and papers for an examination at the suit of the state. This is what I'm standing on. I don't have to give you my papers when you pull me over and demand them from me, because that's back to the Gestapo. Papers, please. Papers. Give me your papers. Oh, well, you're resisting and obstructing, and I'm going to jerk you out of your car and place you under arrest. Now you're under... No, I was under arrest the second you turned your emergency lights on. When I submit to your control, that is an arrest. Oh, yeah. Go ahead and read that treatise on arrest and false imprisonment again. Learn some real law, folks. The individual may stand upon his constitutional rights as a citizen. See? Now, I will admit, under Section 213 in the Law of Nations, that it is a different kind of citizen. We call that people here in America. But, for all intents and purposes, I'm deciphering this right here, is what it truly means is rights of man. He is entitled to carry on his private business in his own way. His power to contract is unlimited. He owes no duty to the state or to his neighbors to divulge his business or to open his doors to an investigation, so far as it may tend to criminate him. So you can't even say that I'm instructing you in conducting your investigation because I have no duty to answer any of your questions. None. Who in the hell do you think you are? He owes no such duty to the state, since he receives nothing therefrom, what? Beyond the protection of his life and property. You are supposed to be protecting me, not harassing me. His rights are such as existed by the law of the land long antecedent to the organization of the state, and can only be taken from him by due process of law and in accordance with the Constitution. It used to say pursuant to the law of the land or due course of the law, because law of the land and due process of law are synonymous. So, and in accordance with the Constitution are one and the same, because the law of the land is the Constitution. And then you have the supreme law of the land. And that Bill of Rights is part of the supreme law of the land. Because the original Bill of Rights specifically says at the top of that document that these are articles in addition to an amendment to the Constitution of the United States of America. That's why they're supposed to be Article the First, Article the Second, Article the Third. That all got changed during the Reconstruction era. Now they call them First Amendment, Second Amendment, Third Amendment, Fourth. No, they're articles because this is a contract. And we require everyone, as a member of the legislative, executive, judicial branch, both state and federal, state, to be bound by that Constitution. So it is an amendment. The whole Bill of Rights is one amendment to the Constitution. So therefore, it is part of the Constitution, and therefore, Article 6, Clause 3 makes the Bill of Rights applicable to the states, because everyone from the state and federal shall be bound by oath or affirmation to support this Constitution. That's part of this Constitution. See the 10th Amendment. That's what makes it applicable to the states. 10th Amendment and Article 5 under the Convention and Article 6, Clause 2, or 3. Among his rights are a refusal to incriminate himself and the immunity of himself and his property from arrest or seizure except under a warrant of the law. Not by law, the law. There is a difference from our rights, not from a statute, not from the code, from the Constitution, from a Bill of Rights. He owes nothing to the public so long as he does not trespass upon their rights. Imagine that, Hale versus Hinkle using the word trespass on rights, because it's a common law trespass, because our rights, common law, are our property. Now, here's the other part. Upon the other hand, the corporation is a creature of the state. It is presumed to be incorporated for the benefit of the public. But the word in is part of that suits in law under Article 3, Section 2. Suits in law. Incorporated. That's a business license. It receives certain special privileges. That's the business license. But see, the legislature is supposed to create the statute regarding that business license. And all businesses under that license are bound by those statutes, which are the laws of its creation, as we will see here in a second, and franchises, and holds them subject to the laws of the state and the limitations of its charter, known as corporate charter. Its powers are limited by law. By statute. It can make no contract not authorized by its charter. Its right to act as a corporation are only preserved to it so long as it obeys the laws of its creation. Now here you go. Back to that. Privileges, special privileges. There's a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. The legislature does the investigation to see if they've exceeded the laws of its creation. It would be a strange anomaly to hold that a state having chartered a corporation to make use of certain franchises could not, in the exercise of its sovereignty, now see, that's where we delegated certain powers over corporations. This is where there is a lack of personal jurisdiction over man in the private. The state has no personal jurisdiction over man or the people in the private. Having chartered corporation make use of franchise could not access as inquire how those franchises had been employed and whether they had been abused, and demand the production of the corporate books and papers for that purpose. Here's just a little tidbit from our Idaho Code, but it's a fundamental principle that proves lack of personal jurisdiction over man on a couple aspects. I know this says open meeting laws, but what does it talk about? Formation of public policy. The people of the state of Idaho, in creating the instruments of government that serve them. Now, I want to back up just a little bit right there. The people create the instruments of government. This is what I'm talking about. Why we, the people, need to come together and reassemble government de jure. Because we have the right to alter, reform, or abolish anything and anytime we deem it necessary. This is why it's so important, folks, that we get on that National Assembly call stuff, get with the people in your territory or state there, nation state, and come together and get this stuff reassembled, get it built. We're running out of time, folks. Going to be stuck under martial law if your states are not reassembled. And these guys are the only ones that are doing this lawfully and have the military support. All the rest of them out there are trying good, I get it, but they just haven't learned the truth and found the root of what needs to be done. And it's too late to try and start something new. These guys are already doing it. Okay, everything else is illegitimate. You have to follow the law of nations and how this is done. Do not yield their sovereignty to the agency so created. This destroys sovereign citizen if they want to say we're the citizens. But see, I just proved that the public servants are the citizens and we are the people or inhabitants. See, the people of the state of Idaho in creating the instruments of government that serve them do not yield their sovereignty to the agency so created. Therefore, the legislature finds and declares that it is the policy of this state that the formation of public policy is public business and shall not be conducted in secret. They make policy, not law. For those in the back that have a really hard time comprehending that what the government makes is not law, it is policy. And it only applies to what the state creates. It does not apply to the people. Get this through your thick heads, people. Hammer this crap home. Furthermore, you want more proof. Want more proof. Okay. Let's go up here to evidence. Let's go to these public writings. Statutes. Now they want to use statutes when we all know that this is all code. But here we go. Prima facie evidence, the truth. Statutes are public or private. A private statute is one which concerns only certain designated individuals and affects only their private rights. All other statutes are public, in which are included statutes creating or affecting corporations. Hale versus Hinkle, it's the law of creation. The statute is supposed to create it, to regulate it. And then those statutes are to affect them, that which they create. It is not supposed to be applying to the people. I don't know how else to explain this, and showing you the facts right here on the screen, right now, of who this policy applies to. I know I'm getting away from the absolute rights and stuff, but we still got some time. We'll get back over there. But there it is, folks. Lack of personal jurisdiction over man. They only have personal jurisdiction over that which they create. Corporations. Hale versus Hinkle. Having chartered a corporation, so long as it obeys the laws of its creation. The contracts, to see if it's exceeded the powers. Corporation. In the exercise of its sovereignty, see, in its sovereignty. But the people do not yield their sovereignty to the agencies created by government. Remember, crimes are supposed to be public offenses, mala prohibitum, prohibited conduct. They can only prohibit the conduct of the corporations that they create. They do not get to prohibit the people's conduct because the law of nature already dictates what our conduct can be, which the very first one is liberty, which we have the right to do whatever the heck we want to do, so long as we do not cause injury, loss, or harm to our fellow man or to the government, right? Then we got a problem. One more thing over here. Even in my stupid, fraudulent Idaho Constitution, which I can prove to you that it's not lawful, but I want to show you even what that says here right now. Article 5, Section 1. The way this is supposed to work. Now, they don't have the authority to abolish suits at common law or suits in equity, and the forms of all such actions and suits are hereby prohibited. You don't have that authority, guys. You're trying to alter the fundamental law, which is what they did. So this is going to have to go Article 4, Section 4, a petition or application to Congress. Because this is domestic violence. This is internal insurrection. Now, anything for what? Protection of private rights or the redress of private wrongs shall be denominated a civil action. So, what we just said there. Private has to do with certain designated individuals and affects only their private rights. Okay, that's supposed to be civil. Those would be suits at common law, which they just subverted the 7th article of the Bill of Rights and the common law as a whole. Then it says every action prosecuted by prosecuted by the people of the state as a party. So you have to have an injured people as a party. What's the name of the man, one of the people, that's been injured by a corporation so that the state can prosecute against a person, a corporation, charged with a public offense. For the punishment of the same shall be termed a criminal action. The corporation pays the fine to one of the people for the damages they caused to the people for violating the laws of its creation. That's how that's supposed to work. But in reality, that's why they abolished the actions at law. It's because at common law, we the people take care of all that. Everything else is supposed to be under admiralty and maritime jurisdiction in them courts of the United States. Famed issues are prohibited, and the fact that issue shall be tried by order of the court before a jury. Notice it doesn't say trial by jury. It says before a jury. So, I know, right? I get it. Well, let me show you one more thing here. And this, and I've already showed this before, but putting the pieces of the puzzle together here. The very, very, very beginning of the Idaho Code. Enumeration of courts. Very beginning of Idaho Code, Title 1, Chapter 1, Subsection 101. Oh, the following are the courts of justice. What happened to the courts of law? I thought courts of justice were in the legislature. Huh. Anyways, it says that of the state is the Supreme Court, the Court of Appeals, the District Courts, and the Magistrate Division of the District Courts. What is this? This is the source, the history. The very first instance is that CCP, which is the Code of Civil Procedure Act of 1881, Section 17. Wait a minute. I thought the Supreme Court and inferior courts are created by and through the Constitution. How is this created by an act? Code. That's that Code of Civil Procedure Act. That's the one that implements the code, the Roman civil law. Everything is code. That's all Roman civil law. This whole thing I'm looking at right now is all code. It's all Roman civil law. So people wonder why we don't get justice in these courts. It's because, like I've called them for years, these are the de facto kangaroo courts. They're government de facto. These are not legitimate courts. None of them. Not even the Supreme Court. And kangaroo courts, which are courts that don't recognize rights. Now let me see if I got that one still pulled up in my PDF here. Yep, I do. Whoops, what did I do? Why is it not? Oh, okay. Yeah, I'll even show you here. This is the first legislative session for the territory of Idaho. Now, notice it says, oh, these are amendments to the Constitution, but they're not. Why does it say article? Article. Article the 7th. Right of trial by jury. Article 6. The mode of trial. In all criminal prosecutions, the accused shall enjoy the right to speedy public trial by an impartial jury. Oh, yeah. Of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, blah, blah, blah. Wait, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Criminal proceedings. Article the 5th. Why did they print it in the first legislative session? This is the Constitution. Why are they printed here as articles? Huh. Because this was right before they changed it, and they can't use this the way it is. They had to change it. It's trickery, folks. But I'm going to show you. Oh, wait. This is the first legislative session. Oh, this is the 11th. There we go. Now, here's that Code of Civil Procedure. Some people like to have told me in the past, oh, no, that's California Civil Procedure. No. Look at it. As it is written, that is Code of Civil Procedure. To establish a code of civil procedure for Idaho Territory. Getting after the legislation, assembly, and territory preliminary provisions. Look at the third section here. The rule of the common law that statutes and derogation thereof are to be strictly construed has no application to this capital C code. That's a thing. The code establishes the law of this territory, respecting the subjects to which it relates and its provisions, and all proceedings under it are to be liberally construed, with the view to effect its objects and promote justice. And then why does Section 4 say the provisions of this code, so far as they are substantially the same as existing statutes, must be construed as continuations thereof and not as new enactments? But the thing is they modify everything. This is in 1881. This is the CCP of 1881. And let's just go ahead and scroll down to Section 17 so we can verify that Section 17 says what it says right there. Like here in 14, no statute, law, rights as law, or rule of procedure is continued in force because it is consistent with the provisions of this code on the same subject. See? They don't care. The code becomes the law. We don't care about your constitution. We don't care about your rights. That's the kangaroo courts. Courts that do not recognize rights. Section 17, there it is. The following are the courts of justice of this territory: Supreme Court, District Court, Probate Court, and Justices. Uh-oh. They've even modified that. The courts enumerated in the first 3 subdivisions of the preceding sections are courts of record. Where's the appellate division? And where's the magistrate division of the district court? See, they've subverted our probate courts and even our common law courts, because that's the justices' courts, is common law. See, there was no appellate court. So they've even altered this. But see, even this is a fraud because it's still all under code. Dang it. Really not getting into the right stuff. But let's jump back over here because this is kind of short. All right. Hopefully that laid out the truth of what we're all being subjected to, because trust me, this happened in everywhere. The code, United States Code, Code of Federal Regulation, Uniform Commercial Code, Idaho Code, Code. It's all Roman civil law. That's what they meant in our Declaration of Independence by fundamentally altering our form of government, subjecting us to a jurisdiction, body of law, Roman civil law, foreign to our form of government, unacknowledged by our laws, and subjecting us to pretended acts of legislation. Okay? Oh, yeah, Robert, out here on YouTube. That's Virginia Declaration of Rights. All powers vested in and consequently derived from the people. Magistrates are their trustees and servants, and at all times amenable to the people, or to them. That's Virginia Declaration of Rights, June 12, 1776. As the theoretical foundation of all government. Right? Karen, I get it. Statute versus code, positive versus non-positive. See, that's the thing, but that's all Roman civil law stuff. Positive law. And no, we have common law, and we have the Constitution, and then we have statutes that are for creating and affecting corporations. That's it. It's supposed to be that simple. Anytime that the rule, the common law, that statutes are to be strictly construed, narrowly construed, what that actually meant was that if the legislature were to make a statute regarding our common law rights, it has to be strictly in strict compliance with the common law. You cannot subvert the common law because the people dictated that's the law before we instituted government. So all these other terms like positive law and all, that's all just more shit made up. It's to cause confusion. Let's keep it simple. We have the common law, which is what the people and the inhabitants, man in the private lives at. When we go over here to the public side, now we're talking about public law, statutes, which are to create corporations and to regulate those corporations. That's it. Keep it simple. This is the way our true republic was created and operated up until roughly 1871, when they switched us over. They created the American Bar Association in 1878. Here in Idaho, they ushered that in 1881. So how do we not know? Well, I can tell you why we don't know, because we've all been dumbed down, and we've all been dumbed down much further. The newer generations here, they've been dumbed down so far they can't even comprehend some of these words. They have no knowledge base of vocabulary. So now this is back to that humbling moment here 3 weeks ago. It's like, oh crap. Kind of felt like a heel, but that's why it was a humbling moment, because I felt bad, is that through no fault of their own, right? And this is having compassion on our fellow man, which goes back to where, a part of this helped me to begin with, was that we've all been taught wrong. But now I'm getting crap. I've got to break this down even further. And some of this right here might even be hard for some of the younger generations to even comprehend the words that are right here. Even though Blackstone's he's really breaking this down. But if we don't have basic vocabulary skills and knowledge of definitions of words and like sentence structure, and there's no way they're going to comprehend this. But I'm going to do my best to try to break this down. So here we are. I'm doing what I can to try and educate the people on what your rights are. And this is a great source of information. You just got to read between the lines and follow the verbiage. And see, here we go back to individuals, but it's still in a state of nature, which is man, is entitled to enjoy. Now I get Fourth Amendment says the right of the people to be secure in their persons, papers, houses, and effects. Because, see, the people are supposed to be in the private, and when we're dealing with private contracts, they'll stay in the private. If it's not a public corporation, public contract that has a business license that's incorporated into the body politic, it's not subject to review by the state. That's in part what Hale versus Hinkle is clearly laying out. I don't know, brother Diesel D's. I don't know if even the honor students. Most kids these days come out of high school, they can't even read, let alone comprehend what they do read. So I got my work cut out for me, because when reading this kind of stuff, it's pretty thick, it's pretty heavy. So even myself have to read this a few times, and then I start getting it. And the more and more I read it, the more and more I commit to memory, which I know is, something that me as a man at 52 years old, it may be quite amazing to some people out there. But I've dedicated my life to this, and I believe, God has put me here for this particular purpose and reason. So now that I've had a couple of humbling events over the last few weeks, it's like, crap. So I kind of feel bad, and so now I've got my work cut out for me, and I kind of have a better understanding of what I really need to do. So without further ado, let's go back to this. So these are absolute rights of individuals. Absolute. It means it's like the utmost set in stone. immovable, unalterable. You can't change them. They, when we're actually talking about is the laws of nature here, natural rights, they come from God, so they can't, no other man or set of men can mess with them. They don't get to alter them and tell us what our rights are. They're already supposed to know this. This is the maxim of law. Ignorance of this law is no excuse. Well, the excuse now is literally we weren't taught proper English. And even myself, I was never taught this stuff in school. Barely taught the Constitution and the Bill of Rights in, when was that? 1987. Okay? But see, every man is entitled to enjoy these absolute, natural, God-given rights from nature, whether out of society or in it. So these are supposed to be that fundamental, that absolute rights, while even as a member of the legislative, executive, and judicial branch, we're all supposed to have these fundamental rights. And this was the intent of creating government, was to secure these rights from infringement. So then how would government itself be able to infringe on these rights? Because they're absolute. But see, this is again why we need to learn what our rights are. Let a man therefore be ever so abandoned in his principles or vicious in his practice, provided he keeps his wickedness to himself and does not offend against the rules of public decency. He is out of the reach of human laws. Okay, so that means that policy that the government makes, the legislature makes, their policy can't reach back over to the private side. Hale versus Hinkle. We're in the private. Our rights to contract is unlimited. We owe no duty to the state to open up our books and papers on suit of the state. Period. That's what that's saying there. Okay? It's out of the reach of human laws. Because see, these are, when we're talking about absolute rights, is from natural nature. The laws of nature is the proper term, proper verbiage. Law of nature. Sometimes referred to as natural law, but that's the trickery. You start pulling away from the true term of law of nature and switch it around and go, well, these are natural laws. And then if you say, well, man gets to make, well, what is natural laws? There's the problem. No. It's out of the reach of human laws. You don't get to touch this stuff. And no matter what policy you make, which one stands on a higher plane? Does the laws of nature stand on a higher plane than the policy? Or does the policy stand on a higher plane than the laws of nature? There's called a hierarchy here. Okay? So, that should be an obvious answer. One's created by man, the other's created by God. What came first? God, then man. Then man-made policy, law, human laws. So, clearly, through hierarchy here, there's no way anything lower can come above and subvert from above. It cannot come in conflict. It can't subvert it. It can't change it. It cannot come in conflict with it because it loses. It's void for any effect. Okay, but if he makes his vices public, though they be such as seem principally to affect himself, as drunkenness or the like, they then become, by the bad example they set, of pernicious effects to society, and therefore it is then the business of human laws to correct them. So now, if a public servant, let's say a city mayor or your county sheriff or county commissioners, you're out at the bar, see them over there partying it up, drinking it up, getting drunk and belligerent and all that. Now, there we go. Now that would apply to them. That's what this is talking about. But this is where the common law kicks in, where, we said, okay, everybody can be free to even do that kind of stuff. But if you commit an assault or battery, now we got to stop that. That's an arrest without a warrant. Assaults and battery come from the common law. So, but as a public servant, they're setting a bad example out there, like drunkenness in the public. They're public servants. They shouldn't be doing that, because that's the business. So, here the circumstance of publication is what alters the nature of the case. Aha. Public sobriety is a relative duty and therefore enjoined by our laws. So when we're talking about public sobriety, public servants. And I get that they're trying to say out in the general public. So yes and no. I mean, I agree and disagree on its applicability. But so long as you're not causing injury, loss, or harm to your fellow man in the private side, but if you're a public servant, then we got a problem. And not just actual being drunk. Right? It's when you start causing a problem. And that's grounds for removal from duty. Religion, therefore enjoined by our laws. Private sobriety is an absolute duty, which whether it be performed or not, human tribunals can never know. Okay, so what that's saying is like in your home at a private, well aren't bars private property? Bars are private property. They're not public property. Even though they have their liquor license and all that stuff, that's to sell. Then they have a business license, right? See, there's part of the problem there. Interdicting all commerce onto the people. How is that actually a public business? Are they getting paid by taxpayer dollars? Are they incorporated into the body politic in service to the people? No. While the business license binds them to certain things, I would argue that it's not actual public, but it is, because they're open to the public. That's the key between public and private. Now, your home, when I have a party and you're drinking it up, that's what that's referring to, private sobriety. There's an absolute which, whether it is performed or not, human tribunals can never know. Well, so-and-so we got pretty drunk there at the party the other night. Yeah, so what? Was in the private. Right to be secure, Fourth Amendment. Or Article the 4th, the Bill of Rights. And therefore, they can never enforce it by any civil sanction. But with respect to rights, the case is different. Human laws define and enforce as well as those rights which belong to a man, considered as an individual. Individual, would be saying as one. Like individual orange and individual apple. That's one apple, one orange, or, See, there's part of the problem with the English language is it's so convoluted. One word could have 3 different meanings. What's the context you're taking it from? As those which belong to him, so individual man, one man. As those which belong to him considered as relative to others. For the principal aim of society is to protect individuals in the enjoyment of those absolute rights which were vested in them by immutable laws of nature. See, there again, laws of nature. But which could not be preserved in peace without that mutual assistance and intercourse which is gained by the institution of friendly and social communities. Right? So that's where we get our common law courts from. If we got a dispute on a local level regarding private rights and private wrongs, we take care of that over here in our common law courts, not in the tribunals created by the Constitution. Do we see the difference there? Common law courts are supposed to be private, and the public tribunals are supposed to be for the public servants, especially under admiralty and maritime jurisdiction. Any kind of a corporation with a contract. Hence it flows, the first and primary end of human laws is to maintain and regulate these absolute rights of individuals. Hence it follows that the first and primary end of human laws is to maintain and regulate these absolute rights of individuals. Well, then they're not absolute if it's being regulated. Maybe hold responsible, but not regulate. Such rights as are social and relative result from and are posterior to the formation of the states and societies. Okay, now we're actually talking about more like political rights, and we're also talking, I guess no, because political rights are a little bit different. The social rights would be like the right to be governor, the right to be a county commissioner, because that's part of the civilized society, a social compact. And again, it says, and are posterior to. So that means after the formation of the states and societies, because that's what a state really is. So that to maintain and regulate these is clearly a subsequent consideration, and therefore the principal view of human law is, or ought always to be, to explain, protect, and enforce such rights as are absolute, which in themselves are few and simple. It's really not that complicated, folks. Once you get this, this stuff's supposed to be common sense, but we weren't taught to think for ourselves. Well, the younger generations, I was. And then such rights as are relative, which arising from a variety of connections, will be far more numerous and more complicated. Okay? So that's when you get into the government and that kind of stuff, the Constitution, that kind of stuff. The absolute rights come before the Constitution. Okay? Laws of nature, long antecedent at the formation of the state. Now, look what it says here. These will take up a greater space in any code of laws. See? There's your prima facie evidence right here that he's talking about the Roman civil law. And hence may appear to be more attended to, though in reality they are not, than the rights of the former kind. Let us therefore proceed to examine how far all laws ought, and how far the laws of England actually do, take notice of these absolute rights and provide for their lasting security. The absolute rights of man, considered as a free agent, endowed with discernment, that's that liberty of conscience, right of self-determination, to know good from evil. So, okay, can any other man tell me I have to wear a mask? No. Because that violates that right of conscience, the right of discernment. I get to determine my own health. Not another man or set of men. No. I don't think so. This is one of the first primitive law of nature. One of the 6 primitive laws of nature is the first one here. When man is properly organized, he knows the difference between moral good and moral evil. Common sense. Either that or they're not of sound mind. And with power of choosing those measures which appear to him to be most desirable, that's that part of that pursuit of happiness, right? Are usually summed up in one general appellation denominated the natural liberty of mankind. This natural liberty consists properly in a power of acting as one thinks fit, without any restraint or control, unless by the law of nature, being a right inherent in us by birth and one of the gifts of God to man at his creation, when he endowed him with the faculty of free will. Now, this next part is the Roman civil law bullshit. But every man, when he enters into society, gives up a part of his natural liberty as the price of so valuable a purchase. What does Hale versus Hinkle say? Now, the only way that this could be construed to be somewhat correct is when man gets elected as governor. He doesn't get to exercise his free will because he is bound to perform the duties as the people dictate in the Constitution. The Constitution dictates the duties that the governor is supposed to perform because the Constitution creates the person called governor. That's the person. Now we've got personal jurisdiction over governor because the people created that and he's subject to that authority. The authority of the people suits at common law. Now, for elected officials, we put in the Constitution that the representatives have to do the impeachment proceedings. But all others that are not elected officials can be drugged right over here to a common law court, whether it's criminal in nature or civil in nature. It's all suits at common law. That's why they took away our common law courts, because the people were doing grand jury indictments against public servants who usurped their powers and tried them in a common law court and removed them from duty. That is the power of the people. All right, folks, I apologize. I know I got really sidetracked with a lot of stuff. I really wanted to get into this. So we will come back to this. Probably not next Monday. I'm probably actually going to take next week off because it's Christmas and all that good stuff. So I want to thank everybody who showed up here tonight live and anybody who watches this later. And I want to thank those that help support me through Patreon or any donations through the mail, snail mail. And I'll go over this again for donations if you'd like to help support here. First of all, kirkslawcorner.com. Here's the link to my Facebook page, Kirk's Law Corner, my Telegram channel, Kirk's Law Corner, YouTube channel, Kirk's Law Corner, and Rumble channel. Now this P here is for Patreon. Okay. That's where I've basically set up Tier 1 and Tier 2, $5 or $10 a month as a donation to help support me. Okay. Tier 3 is where you get into Wednesday night workshop and where I do further education and share documents and that kind of stuff. So if you want to get on a higher level of education than what I'm sharing here, that's more in-depth over there. Okay. Now, Tier 4. Tier 4 is for one-on-ones. I get people all the time hitting me up. Can you help me? Can you help me? That's how I'm providing my help. Other than that, everything else I do for free out here is already out here for free. I've got the educational series for free out there. I do Monday Night Law for free pretty much every week, every Monday. So here's the link to the education series right here. It starts you with this one. And I've showed this before, but I'll show it again. You click on this YouTube. It'll take you over here to YouTube. Okay? And then to get to the rest of them, sometimes they'll pop up over here. See? Episode 2. But what you can do is you click on this right here where it takes you directly to the channel. Then you click on this where it says Playlists. There you go. Educational series. Now you're directly in the playlist that has all of the videos I've dumped in there. Now, again, I've added the right of petition. The right to petition the legislature for the redress of grievances is added in there. And 2 on the Declaration of Independence, Part 1 and Part 2, and the laws of nature from the Law of Nations. Okay? And then, of course, this the Gray State one here. It's 2.5 hours, 2 hours and 40 minutes. Highly recommend watching that one in the end of all this so you can get an idea of some things going on here. But this is all for free. Free education, folks. Okay? That's how you get there from here. And then to for those that want to send me personal donations, this is the office address, which is actually going to be changing, just changing suites, getting into a bigger space, although it's going to be a smaller office for me, but it's going to get a larger space so I can start doing local law seminars and gatherings, and literally moving straight upstairs. So that'll be switching from Suite C to Suite G. Nonetheless, it will still get there because everything that's under 6477 is in the professional office complex part of the strip mall. I don't have a frontage office like the other frontage businesses. I'm in a little community type thing there in the corner. So there's all sorts of offices in there, little businesses. But 6477 West Fairview Avenue, we'll get it there no matter what because I check the mail when I get there. Boise, Idaho 83704. If you want to, and make sure you send it to me at Kirk Pendergrass. If you're doing like a money order or cashier's check, anything like that. Postal money order, anything like that. To me, any cash wrapped in aluminum foil, gold and silver coinage, anything like that. Okay, send that over to the office if you would, please. And thank you for those that have recently sent donations over there. I greatly appreciate you, and all my brothers and sisters over there at Patreon. God bless you all. God bless everybody. God bless America. And of course, I do have to push the plug for what we're working on, because in the end of all this, we have to reassemble. There's no way around this, folks. All political power is inherent in the people. We, the people, have to come together. We have to reassemble government de jure. Take back our power. Trump said at the inauguration speech that he was putting the power back into the people's hands. This is the power he's talking about. All political power. Okay? So, this is what we got to do. Night, brother. Diesel D's. It's the end of the night anyway, so God bless everybody. Get over here on the National Assembly conference call, weekly call, Thursday nights. 6 p.m. Pacific, 7 p.m. Mountain, 8 p.m. Central, 9 p.m. Eastern. This is, you click on that right there. Now, if you're on a cell phone, it'll have 3 little tab up here, 3 hashtags, hash marks, whatever. You click on that, and it'll say home, conference call info, and all these little tabs. It'll show up on your phone over here in the upper left-hand corner. as a drop-down box. Okay? Then you can click on the conference call info and it'll pull up this tab. Now, this is the link right here. I know it's not in blue, so you don't see it as a hyperlink until you hover over it. But this is how to join the free conference call. Now, free conference call is actually an application that you can install on your smartphones or your desktop computer. Okay? Otherwise, you can just dial in. But that sometimes certain cell phone carriers will actually charge you by the minute to dial in. But for those of you that don't do internet, don't do smartphones, you can still dial in. Now, from what I understand, there is a, here it is, a backup number that doesn't charge. So, but I highly, highly, highly recommend, if you've got a smartphone, go to your Play Store, your Apple Store, and download free conference call app. Install the app, reboot your phone, and then come back here. And the first time that you click on that, it will save that. It'll ask you to join this meeting, but it will save it in your drop-down box. So the next week when you come back on Thursday, you can just open up free conference call on your phone and go drop-down box, join the National Assembly call. It will be saved in your little drop-down box, okay? So that makes it even easier. You don't even have to come here and click on this link. You just open up your app and click on join the National Assembly conference call. Now, the first part of it's the business part of the call, and then the second part is education, okay? And then we do a little bit of Q&A in there. So, all right? So, now, Merry Christmas, everybody. God bless. Have a wonderful night. Thank you for being here again. And we will see you in a couple weeks for Monday Night Law. Pray for the world, folks. Pray for mankind. Pray for our enemies, that they have a change of heart. God bless America. God bless the world. Everybody. All right? Love you all. Thank you.